Hello, my name is Gausie.
And my name is Charlotte. Thank you for joining us today as we provide a short summary of the changes to the immigration rules as implemented in October 2013.
As of the 1st of October 2013, anyone who's extending their leave beyond 3 years, who's in the UK as a Tier 2 ICT long term, will no longer have to provide English language. This has been implemented due to the fact that the Home Office have taken on board feedback from many businesses who've responded to the consultations that have taken place throughout the year.
Additionally, the Home Office has made a number of changes to Tier 2 General. For example, those now switching into the Tier 2 General category from Tier 1 graduate entrepreneur used to have to complete the resident labour market test. However, this requirement has now been removed and employers will no longer have to advertise in order to employ these migrants. Additionally, these migrants may also be paid the new entrant salary at the time of the switch, in the same way that those under post-study work can be paid this lower rate, and also those under 26 years of age. This is to encourage people to switch in-country and to make it easier for employers to take on these migrant workers. Further, and this is a broad and all-encompassing change, the Home Office has introduced a genuineness test to Tier 2 ministers of religion and Tier 1 general migrants. This is to prevent these categories being misused and is designed to encourage only those genuinely seeking entry into the UK in this capacity to be able to succeed in their applications. Applicants will therefore need to meet a higher evidential burden in order to succeed. Further changes to Tier 2 General are highlighted on the screen in front of you now. For example, previously, applicants could not own more than a 10% shareholding in their employing business. However, now those earning over 152,100 can hold significant shareholdings, and as at the date of print, there is no defined maximum as to this amount. Further, there have been some corrections, although they are minor, to the weekly hours on which the SOC codes are based in some occupations, in line with the salary sources used. These include the NHS Agenda for Change, Teachers' National Pay Scales, and the Royal Institute of British Architects.
Changes in relation to settlement under Tier 2. As of 1st of October, anyone who's applying for indefinite leave to remain, their Tier 2 sponsor must be A-rated or have applied to renew their licence in order to be able to endorse the settlement application. Please also be aware that as of 6th of April 2016, the minimum salary that applicants need to be earning will be increasing to 35,000, and from the 6th of April 2018, this will again increase to 35,500. There's also been a few changes to the business visitor route. The Home Office have decided to increase the permissible activities, and this has been outlined for you on the slide that you're looking at.
Following the case of Zhang this year, the Home Office has allowed people to switch into the PBS dependent category from within the UK. Essentially, before the rule change on the 1st of October, this was not possible and applicants had to return overseas. Please be aware that although people can switch into the PBS dependent category from within the UK, you cannot switch out of the PBS dependent category. This must still be done from overseas. What this means for you as HR is that you may see lots more PBS dependent visas and applications. It means that applicants can rely on their combined immigration status and switch depending on their situation. So you might see a lot more of those. From a compliance perspective in this regard, you will need to confirm the validity of the relationship that the PBS dependent is in, because their work permission relies on their relationship with the main applicant in this scenario. You should therefore be aware of changes in personal details, next of kin, surname, and changes of address may be an indication that the relationship has broken down or altered, and this may therefore affect their immigration status and their right to work in the UK. Please be aware that PBS dependents are tied to their main applicant and must leave the UK when the applicant completes his assignment, or equally if something changes in the main applicant's circumstances, which means they no longer have the right to work. PBS dependents cannot stay in the UK in their own right and cannot continue to work for you if the main applicant is no longer in the UK.
The English language requirement for indefinite leave to remain applications has changed from the 28th of October 2013. There is now a knowledge of language and life in the UK. What this means is that in addition to the life in the UK test that you need to currently pass, you also have to show the Home Office that you have passed speaking and listening at B1 level or higher in order to qualify for indefinite leave to remain. Following on from the English language requirement change, this has also now been implemented for anyone applying for naturalisation. Therefore, if you obtained your indefinite leave to remain prior to the 28th of October, when it comes to you naturalising, you will need to have a look at whether or not you need to satisfy the speaking and listening and whether you're able to. So this change is now in line with the change for indefinite leave to remain as well.
You may have seen in recent media publications and especially on the news that the Home Office is proposing to implement a new immigration bill. This is currently in its second reading before Parliament and has not yet been implemented. Should the proposals go through, however, there will be a number of increased checks and changes to the current position. These include a requirement for private landlords to check the immigration status of their tenants, to prevent those with no right to work accessing private housing or right to live in the UK accessing private housing. Additionally, they're going to require banks and the DVLA to check the immigration status of applicants before opening bank accounts and applying for driving licenses. This is all designed to restrict the things that those without right to work in the UK can do and undertake. Furthermore, there is a proposal to reduce the number of decisions that can be appealed, from an immigration perspective at least, preserving the right of appeal for those only asserting fundamental rights, i.e. human rights.
Thank you for joining us today, and I hope that you will contact Definitive if you have any questions regarding any of the changes that we have covered, especially if they affect your application that you'll be making. Please find our contact details on the slide here, or alternatively at the beginning of the presentation.